I'd like to welcome everybody to the 2014 August 27th City of Rapid City Legal and Finance Committee. The first order of business is the roll call and determination of a quorum. Here. Thank you. Next order of business with the adoption of the agenda. We do have one addition to the agenda. This time from the Parks and Rec and the Police Department, we'll be bringing forth the state senior games. It's to waive the parking. Chief, I recognize Chief Carl Jegris for 1 second, please. Sir, can you speak to this, or Jeff, do you need to speak to it? One of the two of you for the state games?
Jeff would be best.
Okay, thank you. Jeff Bigler from Parks and Rec.
Good afternoon. I apologize for walking this on at the last minute, but it was just handed to me earlier today. This is a special event application for the state senior games, which will be here in town next week, Thursday, Friday, Saturday, Sunday. Last year we came to you with a request to waive the parking restrictions for the events that take place down at the YMCA. This year we do have two events down at the YMCA on Friday, the 5th, and so this request is to waive the 2-hour parking restrictions around that facility on Friday only.
Okay.
All of the participants, we have about 60 participants who will be using that facility, and all of them will have a placard, as is indicated in your packet that I just handed out earlier. They will have one of those in their windows to designate that vehicle as being one associated with the event.
Okay, and I will make that item number 16A under Parks and Rec Department. And does anybody have any further questions? Okay.
Move to adopt the agenda.
We have a motion to adopt the agenda with the addition of 16A, an item regarding the state senior games. Any further discussion? All in favor say aye. Aye. Motion carries. Now we're on to general public comment. Now is the time for members of the public to discuss or express concerns with the council on any issue not on the agenda. Action will not be taken at the meeting on any issue not on the agenda except for placement on the agenda by unanimous vote of the council members present. I will first go to Mr. Jerry Munson, former mayor. And, sir, you have 3 minutes. If you please identify yourself. Thank you, sir. I will pass these out to the... The floor is yours, sir.
Thank you, Mr. Chairman and committee. My name is Jerry Munson. I'm a lifelong resident of Rapid City, and I just wanted to bring to the committee's attention an issue that was resolved a few years ago, not necessarily in a good way for the financial condition of Rapid City. In December of 2005, a Rapid City Journal article that you see in front of you talks about a lawsuit where 4 days after losing a $3.85 million civil judgment, Rapid City temporarily closed the road through Canyon Lake Park. Also in highlights, in the orange highlights, I show that in the article it says testimony during the trial showed that between 1993 and 2004, at least 7 cars have slid into that same pond. The article's about an injury that was very unfortunate to a young person that lost a high degree of their mental faculties and successfully sued the city of Rapid City because of an issue about a guardrail that the jury found the city negligent and responsible for almost $4 million for a claim. On the back side of your handout, I have also marked that the young person's attorneys argued that successfully that the city was negligent because it didn't plow the park road in the winter, it didn't post warning signs, and it didn't erect a guardrail despite 5 accidents before December of 2000. At the bottom of the page it says his mother comments that she declined to comment, but through her attorney she said that the family filed suit against the city for 2 reasons. The first was to establish a fund for his care because she and her husband can no longer take care of him. And the second was to force the city of Rapid City to take steps to stop young drivers from sliding into the pond. And I bring this to you today because I also have some comments on an item that's later on in the agenda, but I wanted to be able to preface my remarks that I'll be making on a later item with a reminder about some of the consequences of perhaps inaction by the city when it comes to public safety. Thank you.
Thank you, sir. You might as well stand there because we're going to open public comment on your item. Mr. Munson? You can, okay, thank you. Okay, no further speaker requests for us for general public comments. Anybody wish to speak on any items that are not currently on the agenda? I'm going to move on to public consent items, numbers 1 through 16, and I do have Mr. Jerry Munson once again for item number 6.
Thank you again, Mr. Chairman and committee. I took a few more pictures since my approach to the council initially a week ago, and if you don't mind, I'd like to run through just these very quickly. This is overgrown bushes and trees down by Creek Drive, and I ride east from there, and there are overgrown trees behind Taco John's on Campbell Street. They do hit you in the head when you're on a bicycle. This is wattle that's been left there for more than a couple of years behind the Kia dealership. This is the area before the Parks Department came out and fixed the fence, which they have done, and I appreciate that. That's another view of where the path goes over the creek and it's been undercut. That's the new fixed fence. However, to the west of that fixed fence area, there's another drainage area that's about 25 feet away. That's a side view of it, but then you get next to it and it's about 6 feet deep with big boulders right next to the path, and it does drop off precipitously. A couple more pictures of it. There's another one by the Campbell Street Bridge. I would not want to go off that on my bicycle, nor would I want to go off that. That's under the bridge, pretty unfriendly if you happen to fall off the path or slip in any way. These are caused by Atlas storm, and the heavy equipment broke the path up by the swim center. That's the dark tunnel by the swim center. That's by 5th Street Bridge, and you can see the path is pretty high compared to the neighboring dirt. Again, looking at the bridge, there's a drainage next to that bridge. Very easily a place to get hurt. There's water ponding under the 8th Street Bridge, and it does that quite often. And of course, it's terribly icy in the wintertime when that happens to be the wrong time of year for the creek to be up or for precipitation to sit there. This shows the edge of the path by Founders Park, again, probably 5 inches above the neighboring dirt. This is by the Aberesk Law Firm, same situation. This is the bridge on West Chicago, just over 7 feet of clearance, and it does get kind of close for tall people on tall bicycles. That's the bridge by Bacon Park. No water to the right on the picture, which means there's just no drainage there. It's not that the creek's up. It just sits there like that. That's pretty dangerous. This shows that the city of Rapid City knows that in some cases they ought to fence something off, and this is a drainage pipe by 32nd Street. So it says to the citizens, we know there are some things we don't want you to be into, but maybe not all of them are things we're going to protect you from. This is by the bridge on Jackson Boulevard, same thing. This is the bridge under Jackson Boulevard, 6 to 8 inches of drop off on the left side of the path. Canyon Lake Park, by the spillway, same thing. This is on the other side of Canyon Lake. They got a nice fence to keep you from falling off a 3-foot drop off next to the path. But then the fence ends, but the drop off doesn't. So you're safe up until there. After that, you're on your own. And I'm almost done with my comments. So this is behind the fish hatchery, buckled, very dangerous. This is where I wrecked the other day. Shows the situation with overgrown grass. So ladies and gentlemen, I hope that you'll consider as you talk about item number 6, that when it comes to funding public safety, and again in concert with the comments I made under general public comment, this is a serious situation. It's a costly situation for our citizens and taxpayers, and moreover, it's more important to all of us that public safety and people getting hurt can be put at least reduced. Thank you.
Thank you, Mr. Munson. And I have no further speaker requests on items numbers 1 through 16 on the consent calendar. Does anybody wish to speak on those items? None appearing. I'm going to close public comment on those items. Now we'll go to the council lights to see if anybody wants to remove anything from the consent calendar. Chair will recognize Richie Nordstrom.
Thank you, Mr. Chair. Item 6, and let's talk a little bit more about 16A as well.
16A. 6 and 16A. Chair recognizes Steve Laurenti.
Thank you, Chair. Item 13, please.
Item 13. Okay, we have 6, 16A, 13, and 16A. Any further? Richie, are you done?
Yes.
Okay. Okay, I entertain a motion to adopt the balance of the consent calendar with exception of 13, and 16A.
So moved.
Motion by Laurenti, second by Weifenbach. Any further discussion? Motion carries. All in favor say aye. Aye. Motion carries like a Pavlovian dog. Okay, item number 6 is the approve the capital plan for Parks and Recreation from August 2014. And the chair recognizes Richie Nordstrom.
Thank you, Mr. Chair. For start off, I'll make a motion to approve the capital plan for Parks and Recreation for August 2014.
A motion to approve by Nordstrom, second by Weifenbach, and you have the floor.
If I may call upon Mr. Bigler from the Parks and Rec Department.
Mr. Jeff Bigler from Parks and Recreation.
Jeff, in the items that was presented to us just a moment ago, have you had a chance to take a look at them through your Parks and Rec Department board and other committees that you are involved with?
Some of the areas, have been at least discussed. In fact, you do have an item coming to council Monday night for the approval of an engineering and design services for Ferber Engineering for at least a couple of those sections that you saw in the video presentation. The site behind Billy and Kia, where the stream bank is sloughing away, that's one of the areas that we're going to have, that we are having looked at by the engineering company, because there is going to have to be some stream bank mitigation. There's a site near the fairgrounds, which is the pathway is being undercut by the creek. Also, they are looking at the area behind the fish hatchery and a site where the bike path at Cliffside Park is being undercut. So we are taking a look at those, some of the more severe ones. We are also then trying to, we'll be plugging in repairs as funding becomes available for all the other areas as well. We actually did an inventory a couple of years ago and do have an idea. Some of those areas have been replaced, but some of them are still on the plan for repair.
Mr. Bigler, just a quick clarification on item 6. Those items that you just suggested have not made it to that list. Am I correct on that?
Well, we do have some funding. We have a line item for bike path improvements in the current capital plan, and some of those items are going to be addressed with funds that are currently available.
And then we will be probably seeing future items come up in future CIP meetings.
Absolutely.
Thank you. I'll yield the floor.
Okay, Chair will recognize Alderwoman Darla Drew.
Okay. I thought I was good with microphones, but I guess not. My question is, until we get these repairs made, should there be some kind of signage, warnings, something like that, maybe even to exempt the city from responsibility, construction underway, right at your own risk, something like that?
I don't know. I may have to defer
Might
to
want
the
to
attorney's
defer to the
office.
attorney on that
Funding,
one.
yeah.
I'd want to give that a little more consideration before we go out. There may be areas where, yes, it's appropriate or more appropriate to take action or put up a warning sign. That argument is that can kind of cut both ways, that you knew about a danger and you didn't do anything about it. On the other hand, if you warn people, then you can say you at least did do something. So probably case specific. I don't know. I mean, part of it always comes down to money. Do we have enough money to fix every single problem on the bike path? No, probably not. Do we have enough money to put up signs everywhere? I don't even know if we know what that would cost at this point. So,
Well, maybe not signs everywhere, but maybe in the most difficult areas where there could be injury, that we should have some kind of signage, because we probably won't get to fix everything, as you said, at least not this year. Maybe within a couple years, all those repairs will be made. But where you have a 6-inch, drop off, at least, I think that there should be some kind of signage or warning. And then for the water under the bridges would probably be at least something that people should be aware of. That's what they're going into when they go under the bridges. Thank you. I yield.
Chair will recognize Alderman Ron Weifenbach.
Thank you, Mr. Chair, but I think Mr. Beegler had something to say, so.
Thank you. I was just going to mention regarding the underpasses when they're full of water, when we become aware that the creek is rising or an issue, severe runoff from a rain event, we do put the orange fencing just across the bike path just as an indication. However, it's not a complete barrier. People can still go around that if they choose to do so. That's what we have been doing out there, just to at least give a heads up that's happening. And it's been happening a lot this last year, though. The water's been high most of the time going through the creek. And so some of those underpasses, the pathway is not much higher than the creek level. And so when it does come up, it floods the pathway.
Thank you, Jeff. And Mr. Mayor Munson, I appreciate you bringing forth the concerns on the bike path. I think the bike path is one of our premier items that we have to offer the people in our community, and obviously the safety issues need to be addressed. So if there's a way that maybe we could be kept in the loop on the priorities, and if you're falling short on funding, I know it's obviously an issue in everything we do, but we're looking at those issues all the time of prioritizing funding. One of the things that council's challenged with is safety. And if anybody uses, I mean, the bike path and the walking path are used, I mean, the worst case scenario is we wear them out. But if we don't take care of them, people are going to get hurt. They're not going to want to use them. They're going to deteriorate. So we need to just have some priorities, Mr. Beegler. And if you could maybe keep us in the loop and maybe Mr. Munson in the loop, since he uses the bike path a lot. And I'm assuming a lot of those look like smaller items that the parks could handle themselves. I would probably have some questions for you later about why our engineers can't handle some of the other smaller drainage issue things without having to go out for services on those. But so if we could just get a list of priorities, and if we have to, reevaluate where our funding goes, where the money goes, I think the bike path is important. It's important to everybody in our community and keeping them safe. So appreciate it. Thank you.
Thank you.
Chair will recognize Alderman Steve Laurenti.
Thank you, Mr. Chair. I had a question for Mr. Beegler as well, if I could, please.
By all means.
Mr. Beegler, do you think it's appropriate that the City Council, or maybe at this point Legal and Finance, direct staff to assess what the Mayor Munson has brought forward? Do we need a full assessment of it? I understand you've spoke about that you've assessed some of those areas, but do we need a full assessment so that we can have the City Attorney's Office get involved after that assessment's made by your department and then make a decision as to, what needs to be mitigated? Obviously we don't want to put padded walls up for the entire length of the bike path, because that would ruin the whole ambiance of being on the bike path. And obviously we can't protect people from themselves, right, or from stupidity, or from doing wheelies on the bike path. But the fact of the matter is there's probably somewhere in between, and I think the former Mayor Munson has brought up some great points. So do you think that there's a necessity for us to direct your staff to do that assessment, or is that something you have in mind already?
Actually, yesterday's Public Works Committee, Alderman Wright asked that we come back to the Public Works Committee meeting, the first one in October, with kind of a more comprehensive assessment from one end of town to the other, and perhaps a better idea of cost to make all of those repairs. And so we will be coming back with that. I think this is also something that I'd like to get in front of the Parks and Rec Board, and so we'll be bringing that up with them as well at our next Parks and Rec Board meeting in September.
Okay, thank you, Mr. Beegler. And then, Chair, if you can, I would like to ask Finance Director Pauline Sumption a question, if I can, please.
Please. Pauline,
can you tell us, because there's some things further on the agenda for the 2014 Council Contingency Fund. Where are we sitting with balance? Given that there's some money dedicated to the PD fleet management situation that we're all aware of, and of course, given number 16 on the agenda today, I'm just trying to figure out what's left in contingency for 2014, because I don't want to touch 2015. So,
thank you for the question. Actually, both for the police fleet and the $25,000 for the cemetery are on today's agenda. So if you guys approve both of those transfers out of the council, mayor and council contingency, that will only leave you with $25,000 for the remainder of the year.
We just approved them.
Oh, that's true, you did, except for, yeah, you did with 16 too. So if the council were to approve them on Monday night, that leaves you with 25,000.
Okay, that's what I wondered, because I knew we had just approved 16, and granted, it's very easy for me, I won't speak for any of the other council members, but given maybe some funds we may need for some mitigation on the bike path, I would be more than willing to shift that $25,000 from the cemetery to the bike path. I sure as heck do not want to put more pressure on the 2015 budget, because I think we've already spent ourselves too far there. So I would love to see that rededicated on Monday night, if necessary, to the bike path as it may be needed. So just something for my colleagues to consider. I yield the floor. Thank you.
Thank you, Mr. Laurenti. The motion is to approve. Any further discussion on item number 6? All in favor say aye. Aye. Motion carries. Item number 13 is to acknowledge the 2014 sales tax report. Motion, or Chair recognizes Steve Laurenti.
I'm going to make a motion to acknowledge that, and if I could maintain the floor.
By all means, motion by Laurenti, second by Weifenbach to acknowledge.
Thank you, Chair. And I have one more question for the City Finance Officer, if I could, please.
Go for it.
Pauline, this is more rhetorical, but I just want everybody to hear it from you. Our budgets are typically based on the 2014 and the 2015 budget that we're about to vote on again are based on what assumption in sales tax in growth?
The budget for 2014 was based on 2012 actual plus a 2% growth for 13 plus a 2% growth for 14. And in 13's growth, it was 3.25%.
Okay, thank you very much. I just wanted to have her answer that, because it's an acknowledgement of the sales tax report, and we've all seen it. However, much of the public hasn't. I mean, they have access online, and they could see it if they wanted to. But so far, through June, we're at 5.5, just over 5.5% growth, which is outstanding. And I just wanted the public to know that the good part about keeping the money in the taxpayer and the money earner's hands pays off for the city. And we are on a very good growth pattern, which is going to help us not only for 2014 budget, obviously, but for 2015 and moving forward. So I just wanted to pull that item and bring that to light. Thank you.
Chair will recognize Pauline Sumption, the Finance Officer.
Thank you, Mr. Chair. And I guess with that being said, I feel it necessary to reiterate the email I sent out to the department heads and to the council's members yesterday, as well as the mayor. It does show a 5.51% increase through the first 6 months of 2014 versus the first 6 months of 2013. But as I've told department directors and elected officials time and time again, do not get excited about this number, because we still have 6 months to go. And in that email, I showed you what happened last year, where the first 6 months of 13 over the first 6 months of 12 showed over a 9% growth, but we only ended the year at 3.25%. So if that trend continues into 2014, we're looking at less than a 2% growth for the full 2014. So that's why I caution you over getting too excited about that number mid-year, because there's a lot of year left. So thank you.
Duly noted. The motion is to acknowledge. All in favor say aye. Aye. Motion carries. Item number 16A is the State Senior Games waive the parking restrictions by the YMCA. And Chair recognizes Alderman Richie Nordstrom.
Thank you, Mr. Chair. I'll move to approve. And if I can have Jeff speak on this just a little bit more.
Motion to approve by Nordstrom, second by Laurenti, and you may have the floor.
Thank you, Mr. Chair. Jeff, just to reiterate, these types of projects or events have taken place in the past, and this is just a new location?
That's correct. Actually, we used this location last year as well, and we came to the council to get a waiver of the parking restrictions for that event as well. There are a number of different events, and they're being held kind of all over town at different locations that have a venue for those events. And the volleyball and pickleball location this year will be at the YMCA.
Thank you, Mr. Bigler. Are you joining in on the games yourself?
No.
Oh, thank you. I'll yield the floor.
Chair recognizes potential participant Darla Drew.
I'd like to know if there are other events that are also given priority for free parking downtown, or if this will be setting a kind of a precedent for this type of an event. Is this new?
It's not new. I don't know about other waivers for other organizations. This is the only one that we've ever requested.
If I might interject, we do that for a lot of different events,
Yeah.
as I'm sure the Police Chief Carl Jagers could explain to you if he.
Yeah,
had a
could you
second.
give me some examples?
In the recent past, at the Elks Theater downtown, a senior movie night in the air, or I think it's a daytime event that's occurred on occasion. Whenever those requests come forward, we bring them to council for approval, and in this case, we would be able to accommodate that. It would be important for our parking enforcement staff to have a clear understanding of what it is that we're not to enforce. So in this case, I would recommend on the days of the event that we seize parking enforcement for 2-hour violations in the area west of Mount Rushmore Road and south of St. Joseph Street. And then we would still enforce handicap violations, loading zones, and those kinds of things.
Well, the reason I was wondering is when I was at the Doll Arts Center, we would have the New Horizons band, and they would, of course, they would come in early, they'd have lunch, they'd hang out, they'd be there for 3 hours, and we had to be constantly feeding the meters. So that would be an event that we, could be waived.
Well, that would be up to the council. We at the police department would not do
Okay.
so, but you're correct. It is a slippery slope. Once you start waiving parking ordinances for one special group, you're likely to have more special groups come forward.
I would guess so. Thank you.
No rodeos. Up next, we recognize Chairman Richie Nordstrom. Alderman, excuse me.
Thank you, Mr. Chair. I get confused sometimes, too. Just want to make sure that we have that in our motion, that the boundaries that the chief has identified.
I'm sure that's part of the permit.
Yep.
Yeah.
I didn't see it in the application, but I just wanted to verify. Thank you.
I trust that the
Floor.
police department will do their job. Up next, we have no further discussion. So, all in favor, say aye. Aye. Motion carries to approve. Okay, on to items 14 through 22. Public consent item. Public comment is now open on items numbers 14 through 22, non-consent items. I have speaker request forms of number 17 from Mr. Lyndon Bolt and Mr. Bradley. Am I to assume you are to? Excuse me, sir? 17, excuse me. Are you here for standing by for questions, or do you wish to address the council?
I think it's more standing by for questions.
Okay. It doesn't have either one. I'm moving on to item number 18 from Ms. Denise Ross. If you'd approach the podium, please, ma'am. You identify yourself for the record, please, ma'am.
Yes. I am Denise Ross. My husband and I own our home at 3210 Kirkwood Drive in Chapel Valley. Dave works as a nurse at the hospital, and he was not able to leave work to attend today's hearing. The facts in our matter, which I think you'll get to here after I'm done talking, are pretty straightforward. We hired James S. Steel Construction to replace a 30-plus-year-old roof on the fixer-upper that we bought in 2010, and they did a substandard job.
Excuse me, ma'am. I'm going to caution everybody at this point to just leave it to the facts, and not, I don't want to allow any slanderous comments about anybody publicly. I'm not saying that it's your opinion, but I just don't want to get into a big kangaroo court here at this point. So
Okay.
I think it's just best we don't do that. It's not fair to everybody involved.
Okay. I think I'm okay, but you let me know if I get
Sure.
out of bounds,
I'm just-
okay?
I was just trying to keep it personal, I guess, my question.
And I'm just trying to stick with what led us up to getting into the building board process. They did not complete all of the work in our written contract or verbal agreements. They overdrove a substantial portion of the nails, many shot completely through the shingles, as the photos submitted to the building board show. And as it turns out, they violated some city ordinances along the way. We tried starting on day one of the job to get these matters corrected. My husband had worked for 15 years in construction before going to nursing school, and he was able to spot the problems right away. Despite our repeated efforts to get the problems corrected and later to settle this matter amicably with Mr. Steele for a few $1,000s off of a $30,000 bill, he chose instead to file a lien on our home and to sue us, as court records show, he has done to several other homeowners over the years. In midsummer of 2013, after he had filed the lien but before he had filed the lawsuit, my husband visited with the city's building services department to check on whether all of the needed building permits had been secured for our job. And that is when the city staff informed him about the building board process, which we chose to pursue. Now, in the letter and the other materials that Mr. Steele and his attorney have submitted to you, they have taken great umbrage with the fact that we have followed the city process. But as I stated before, they have not paused when it comes time to sue homeowners when they seek corrections. As you know, the building board found James S. Steele Construction in violation of 3 city ordinances at their November 2013 meeting. At that time, Mr. Steele did not deny the ordinance violations. His position throughout this process has been that it should not matter to the homeowners or to the city that the job was not done properly. Leaving decades-old felt and flashing on should not matter. Not inspecting the roof deck for defects after more than 3 decades should not matter. Overdriving nails extensively should not matter, regardless of what's in the city ordinances and the building codes and the memos that the city issues to contractors. As you also know, earlier this month, the building board voted unanimously to suspend the contractor's licenses for James Steele Construction until they correct the ordinance violations on our roof. That license suspension is what they are appealing here today. I told the building board that we do not object to granting James Steele Construction some time to perform the work, and our position has not changed. As some of you might recall, when I visited with this committee on June 11th, I suggested a system of fines that seemed more reasonable in these matters than license suspension or revocation. And since then, I believe I have found in the ordinances just such a system.
Ma'am, could you please wrap up your comments, please?
Okay.
Thanks.
We believe the building board's determination that the ordinance has been violated ought to be enforced in some way, but we're not too hung up on what that enforcement looks like. We submitted a written request to the building official asking for suspension or revocation because at that time we believed that was the only option available. I think that'll do it.
Okay.
If you have any questions, I'll be happy to answer them.
Thank you, ma'am.
Okay.
I'm sure you'll be available for comment when we get to that subject, so. Okay, up next, I'll recognize, I assume, George Nelson, the attorney for Steele Construction, I assume. And item number 18.
Thank you. I'm
17, pardon me.
I'm here on behalf of Jamie Steele, Jim Steele, and Steele Construction. I've presented to the board on their behalf 16 pages. There's, I believe, at least 71 pages there already on file in regards to this matter. A lot of material. I think the core issue here is whether or not the Board of Appeals had jurisdiction to hear Ms. Ross's appeal. This is how the thing started. Ms. Ross did not like the fact that the Office of Building Inspection approved the re-roofing that my client had performed on her residence. She contacted the city and talked to a couple of individuals, did not like what she heard. She sends a letter to the Board of Appeals. That apparently, I'm not sure when that was sent. I've inquired on that as to whether or not it was timely. It's my understanding that she had 22 days to submit an appeal, and the building permit or the approval of the re-roofing was done. It was approved on the 1st of March. The correspondence that I see essentially begins in July. So I believe for the City Legal and Finance Committee, that's the core issue, the first issue it would have to decide. If the Building Board of Appeals did have jurisdiction to hear her appeal, the question is, what was the appeal? Was it the appeal of the permit or the appeal of what she heard from orally from members of the city staff? It's uncertain, but there should be a determination as to what that appeal was from. All this is important because whether or not this committee agrees with my client's position that the Board of Appeals improperly ruled against my client, it sets the record for my client for other recourse that they may have. So in regards to that, I'll yield to any questions that the committee may have.
And we'll get to that item, so we might very well do that. Item number 18, next speaker request form is from Mr. James Steele. Do you wish to speak, sir, or do you just want to stand for questions when we get to your subject? Okay, great. Okay, we're now finished with all consent items numbers 17 through 22. Does anybody else wish to speak on those items? Public comment? Sir? Could you please approach the podium and identify yourself, please?
I'm sorry, I didn't realize that a person needed to turn in a speaker item.
That's why I asked the question, so
Okay,
you're fine.
I'm sorry.
Could you
My name is Lon Buhner.
And which item will you be speaking on, sir?
The one on James Steele.
Okay, item number 18. Okay, thank you, sir. You may proceed.
Okay, thank you. In 2010, after a severe hailstorm, my neighbor hired James Steele to replace various items. She came to me because she was concerned about the quality of the work. In the end, she had paid him a large sum of money initially. After the work was done, he invoiced her for additional monies. We had a lot of concern with regard to the invoicing, with regard to some of the quality of the work. We had a meeting with Mr. Steele, we being my neighbor, myself, and Mr. Steele. We voiced our concerns. We didn't get any headway made. I wrote him a 2.5-page letter to document what our concerns were. Several months later, my neighbor came over crying because she had been sued by Mr. Steele in small claims court for a little over $5,000. I explained to her that it looked pretty clear to me that she was in a very strong position, and so she elected to deny his claim and countersue for a little less than $3,000. I furnished about 4 pages of information and everything to the court that I was going to be presenting in hopes that Mr. Steele would take a look and try to deal with this matter out of court. That did not happen. It went to court. The judge ruled, and in her findings, she did make the statement that Mr. Steele's company performed the work poorly. She denied all of his requests. She granted all of my neighbor's requests. So while she was sued by Mr. Steele for $5,100, in her ruling she stated that she found everything in favor of my neighbor and she received a little less than $3,000. Thank you.
Okay. Chair will ask if there's any more people who wish to speak on those items. Okay, moving on. Public comment is now closed on items number 17 through 22. Item number 17 is to appeal the Building Board of Appeals decision regarding contractor's license of Linden Bolt.
I make a motion.
A motion to deny by Laurenti, second by Richie Nordstrom. Richie, you have the floor.
If I may, I just want to clarify what the board came up with. The decision is not to revoke or suspend the Bolt Construction's contractor license. I just want to make sure that that's the motion, and I'm comfortable with that, and I'll yield the floor.
That is the motion, as I understand. Is that correct, Mr. Laurenti?
That is.
Okay. Motion to hold decisions by Laurenti, second by Nordstrom. Mr. Weifenbach, you have the floor.
Thank you, Mr. Chair. When I was on the council before, it was my measures that led to this building permit process. And what we see here today is, after installing this, during the hailstorms, people would come and go, and people in our community had a certain level of confidence by a contractor having a license and the ability to adhere to the code. What had happened is a person owned a house, re-roofed his own house, and put 2 layers of roofing on the house. The Board of Appeals wanted them to rip all the roofing off of his house. And unbeknownst to him, he didn't have to have a permit at the time, and it became aware of the fact that this was probably happening throughout our community with the elderly people in the community, less expecting people in the community who thought that the contractors were held to a different level or different standard. Understanding that on this item, this person has had several years of experience in the business of contracting, looking through the notes and everything I had, There is an affidavit in this material that we received that this person installed this roof according to the manufacturer's specifications. He signed it. When I'm going to backtrack a little bit, but putting this process in place, it was evident for the contractors that physical inspections weren't going to work all the time. So the city came up with, and I applaud the fellows in the city department here to go, you know, we need to work with these guys. We have short windows to get these things done. So they came up with a process that said, hey, listen, we're going to rely on the contractor. We're going to make you sign an affidavit that says you did what you did. I'll guarantee you, if Ron Weifenbach signed something that says he did what he did it. I'm not here to deny it, and if I didn't do it, I would stand up to that, and I would make it right. In this case, the city has come back and done an investigation, extensive investigation, have come up with factual information that is not the case. And yet we're going to, on this motion, tell this person that it's okay to do that. I disagree with that. I think what there has to be done is there has to be some sort of responsibility for your actions. In this case, Rana Graham expected that since the building permit would go back, the roofing was done on a Sunday, the builder came back on a Wednesday and then got the permit after the roof had already been built. Okay, he acknowledged that, paid the fine. But the fact of the matter is, if you have several years of experience in this, you understand that a building permit typically is drawn up front. I think that's what the expectation is. Also, there were no pictures taken, so we don't actually know, from the understanding of the information I was given. Typically, there's pictures taken of the ice shield and the process that takes place when the roof is put together. That stuff doesn't exist. But yet, our city filed that inspection, which is wrong. In my understanding, due to the record, that's public record, that those employees have been reprimanded for that. They since have turned around, unfinalized that same building permit. And yet we're going to tell this contractor it's okay to sign an affidavit, which I understand is a legal document, stating that this roof was put on according to manufacturer standards. And it's clear from the information that was given, or I should say, the city's work, that it was not. We got an issue here. At some point, we got to draw a line in the sand, and I think it's time to draw the line in the sand and get this resolved. Either through the only two options I see that we have are a suspension or a revocation of this license. There was an inherent thought process of Rana that getting a building permit would, at least, it doesn't go to the workmanship or any of that other stuff. I don't have any concerns about civil proceedings or any of those items. That's not for us to decide. We're here to decide that, number one, the building permit was taken out on a Wednesday after the roof had already been built, which sometimes these things happen, I understand, and there's some things in place for that, and we put a little bit of trust into our contractors to handle that. And in this case, no pictures were taken, which was expected by the people that inspected. Those pictures weren't taken or not made available, or whatever the case may be. I'm not exactly sure, but from understanding all the information I've gathered, so I'm not gonna vote to uphold the appeal. I think there needs to be some ramification here. There needs to be an understanding that building permit, there's a process and procedure in place. That's what we do up here. We make process and procedure, and our citizens believe that the process and procedure is going to be followed. In that process and procedure, there was plenty of flexibility for this to be done within an area that made sense. We went outside of that, beyond that, in this case, and I think that that's wrong, and I think that when you do not you do not adhere to what you said you did on a signed affidavit, I think that's a problem. That tells me there's a level of trust that's been violated from that contractor and the city. If I'm mistaken on these items, I could stand corrected, but that's how I understand it. So with that being said, I'm not going to support this motion. Thank you.
Chair, we'll go to, excuse me, Alderwoman Darla Drew, excuse me. Richie's already spoken once.
Okay. Well, I talked to Rana last night, and it's my understanding that there were photos taken. I don't know if anyone's seen those.
There.
And also that the photos were taken after a no trespassing order was issued to the contractor.
That's correct. I think it was April the 23rd when Mr. Bolt had his employee Josh go up on my roof, and the no trespassing letter that was sent to him advised by Rapid City Police Department was issued on February the 18th.
Did you take pictures then after the work was done so that you could show that it was substandard?
My contractors, which should be in your files, Black Hills Exteriors, the two independent contractors, they took photos from the start, and Pro Exteriors, they should actually be in your packages showing what the roof and the issues with the roof.
The issues with the roof are?
The starter strip, they did not use correct starter strips for manufacturer's code. The reports from Pro Exterior and Black Hills Exterior state there are overdriven nails. The roof is not sealing, which the city inspection team came out, said they saw two shiners, which in the reports actually state there are numerous shiners. They stated that the roof was not sealing. It's still not sealing. I issued you with a letter today from a contractor stating we now have water actually coming in from our roof now. We didn't know this until the last storm, which I believe was around the 9th or 10th of August when we had the really heavy rain. Because we didn't have a lot of rain throughout. We might have had a lot of snow out the winter, but not rain. And we've noticed wet marks coming through in our garage ceiling, and a contractor managed to come out yesterday and inspect it, and he said he can't pinpoint the exact location of the leak at the moment because it's too dry, but he noticed that the shingles are not sealing, and that what could be happening is with the heavy rain is lifting them up, and the rain is actually going in, which could be causing the leak itself.
And I understand all those problems, and I know you've tried many different avenues to get this taken care of, and each time you've gotten met with a no.
Yes.
And so it's my inclination to say, regardless of what Alderman Weifenbach says, this is probably not a city issue. Thank you.
Chair recognizes Alderman Richie Nordstrom.
Thank you, Mr. Chair, and I appreciate the opportunity to speak again on this subject. I was just trying to pull up the city attorney's investigation report, and I was mostly relying upon what that report had to say as to my determination for my decision for stating why I'm not in support of the denial or the appeal and support to the board. And with those comments that are specifically addressing 4745 Mandalay Lane, based on that reasons why that's in there, and I understand it's maybe a little bit of out of sequence, but that's the main reason I'm supporting the board's decision in that report from the city attorney's office to the Board of Appeals. And I know that the city attorney also put together some other comments that need to be addressed in there for another time, but essentially the conclusion that the city attorney came up with is the rationale that I'm using to support the denial of the appeal. Thank you.
Chair, we'll go back to Alderman Steve Laurenti.
Thank you, Mr. Chair. I rise in support of the denial to uphold the Board of Appeals decision, primarily because of what Mr. Weifenbach, Alderman Weifenbach, has said, and I appreciate his opinion on the matter, absolutely. But I think in this particular case, that's exactly what we've done. Based on what they have put together with this process, with the Board of Appeals, this has gone finally to the Board of Appeals, which is where it should have gone a long time ago. I think, Mrs. Graham, I appreciate the problems you had, and I hope that if there was wrongdoing or things that both the contractor and the city staff can learn from this, I hope that it's been learned by you coming forward. So I appreciate your doing that, because it takes a lot of guts to do what you've done. However, on the process, that's what I'm here to do, is uphold the policies and the process that this council puts forward, and that's exactly what we're doing. This has gone to the Building Board of Appeals, and the Building Board of Appeals has given us a decision, and I think they looked at all of the matters that have been presented to this council time and time again, and they've made a fair decision, and I support that decision because it's a good policy for me to support the very policies and processes that I helped put in place. So I yield the floor. Thank you.
Chair recognizes Alderman Ron Weifenbach.
Thank you, Mr. Chair. And I have my question for Mr. Landine.
By all means.
Is it part of the process for a citizen to bring it to the council if they don't agree with the Board of Appeals? Just making sure. We still have
Yes,
the process.
obviously, it's in front of the board right now that the decision on the licensing issue can be brought to the council.
The other question I have is how do we finalize in case of a fact when we don't do the physical inspections, how do we finalize a building permit? What do we do when there's no physical inspections?
Are you talking about on the roof or on the?
A roof, on a roof, I'm sorry, yeah.
Well, they
matter
accept
at
the
hand, I
affidavit.
guess. Pardon?
They accept the affidavit.
Accept the affidavit.
The sworn statement that the roof was done correctly.
I think that's practical to handle most situations. Okay, and I appreciate that. But the problem is the affidavit has later come to light that the affidavit didn't match the reality of what transpired. So I'm bewildered, but I've said enough, and I'll have another conversation Tuesday. Thank you.
Okay, the motion is to uphold the decision of the Board of Appeals. Any further discussion?
Mr. Chair, could I address some of the issues raised by?
At this point, does anybody have any questions for Mr. Bradley? We're about to render a decision, so you might want to, it's up to you, but I guess, does anybody want to ask him a question? No one has any further questions for you at this point, sir. All in favor, say aye. Aye.
No.
Opposed?
No.
Motion carries with 4 to 1. How about that? Item number 18 is James Steel Construction, appeal of the Board of Appeals, suspension of James Steel Construction contractor license. We have a motion to deny the appeal by Steve Laurenti, second by Richie Nordstrom. Chair recognizes Ron Weifenbach.
Mr. Chair, so what does this mean then?
It means the suspension will be upheld.
That we just had this conversation and.
This is a different.
So I've read both.
Yeah.
Yeah. I have questions for the person that's involved in this because as I read the material in this one, I'm trying to understand what the differences are. So I guess if there would be someone here to speak towards the differences, someone from the Board of Appeals or something, to see the difference between the two, why we ruled one way one time, one way the other time, and.
I guess Mr. Attorney Joel Landine can answer that question, hopefully.
Thank you, Mr. Chair. No, I actually wasn't at the meeting, but my understanding is the distinction that weighed heavily on the board is that with Mr. Bolt, he was legally prevented from going and correcting the any deficiencies. So how could they revoke his license because he didn't go fix the deficiencies on the roof when he was legally prevented from going onto the property? Whereas Mr. Steele, the board felt they had previously identified some corrections they felt needed to be made, and he had not gone out and made those corrections, and he had no, there was nothing legally preventing him from going on the property. I see Allison stepped out. If she comes back, or perhaps, were you involved in this one, Carla? I mean, is that your understanding of the board's decision, or?
Chair recognizes Carla. Could you please?
Carla Cushman, Assistant City Attorney. Joel is right about the distinction that the building board made. I think I was in attendance at the meeting, and I think one of the other elements that they looked at was the types of violations. With Mr. Steele, the board had found the violations, and they had found that there were 3 of them at the November meeting. And in the case of Lyndon Bolt, this was the first time it was before the board. So that's a practical difference between the two. But a large part of it was, as Joel said.
This is incredible to me. So absolutely, if Rana would have went to the Board of Appeals and stated her case, and then they would have come to some conclusion, and then later he didn't fix it, he could get his license suspended. That's what we're saying here, correct?
You know, it's a difficult situation because the board, even if there is a violation, I mean, really the purpose of licensing is to protect the public. It shouldn't really be a tool to resolve specific disputes between a contractor
Mr. Chair,
and
Mr. Chair.
He's answering his
Can we
question.
hold it to the facts?
I'm going to let him answer the question. Thank you.
So, you know, when the board is looking at a licensure, I mean, there is a balance between, okay, we've found violations, we want to see them corrected, and also, do we need to suspend this person's license to protect the public? And in the one case, they were clearly upset that they had found violations and wanted those to be corrected, and has been discussed previously, their only tool at this point in order to achieve compliance with their order is to suspend or revoke the license. They wanted to see these corrections made. In the situation, whether you agree with it or not, they looked at the situation with Mr. Bolt, and even if they wanted to order corrections, he is legally prevented from going on the property and making corrections. And did they feel it was fair that they suspend his license based on him going and fixing that a defect that they knew he legally couldn't go out and fix? Clearly they didn't, whether you agree with that or not. Now, on the other hand, Mr. Steele could go out and legally fix those corrections that need to be made. There was nothing that legally prevented him, so they made the choice to suspend his license in order to compel him to go correct those and address that issue. But again, I think we have to keep in mind that the purpose of licensing in general is to protect the public, not deal with specific disputes. As has been indicated, both of these matters are already in court, and that's what courts are there for, to resolve these disputes, weigh evidence. They have a lot more tools in court to weigh the evidence than we have. So,
Mr. Chair.
Yeah, means.
I appreciate that, but earlier you asked someone to abstain from their opinion. I'm here talking about ordinance facts, about information that was given. I have no regard to any civil disputes that they have. Let's make that clear. That's not what I'm talking about. I'm talking about the ordinance violations, the affidavits that were signed, and I guess the next question I would have is, what are the ordinance violations that are specific to this case? What are these ordinance violations that they found in violation? Couldn't identify them in the information that I had available. Also, I understood there was no pictures. So I'm not sure if there was physical inspections on the roof, how they found this stuff out, whatever. So I guess I'm not sure who to ask that question. So, I mean, I want the fact, and I don't want either side. I want someone from the city to tell me how that decision was made, what those ordinance violations were.
Brad, do you know what the violations the board found were, rather than rely on either of the interested parties?
Chair would recognize Mr. Brad Salone from the building department. Excuse me, growth management. Or community planning. I'm stuck in the 80s.
Thank you, Mr. Chair. I'm Brad from Development Services. Now, in my memo to the building board, I'll just read it. In 2013, James S. Steel Construction, work was done at Kirkwood Lane in 2013 by James S. Steel Construction that included re-roofing and replacement of windows in the roof. In the fall of 2013, the board heard a complaint from Ross Larson that stated that re-roofing was incorrect and that a permit was needed for the construction work. The board ruled that flashing was incorrect, the second layer of felt was incorrect, and the overdriven and crooked nails were incorrect. The board ruled that a permit was not needed for the skylight framing installation in the roof.
Yeah, I read that, but to me...
That's what we told them.
I did read that, but then I also read there was no pictures. I mean, who came to this judgment, and how did they come to this judgment? I mean, my assumption is if you don't physically inspect it, that we require an affidavit that says it's installed to manufacturer specifications, And that's in case, now that's another question. And number two, pictures. And in that memo somewhere, there says there's no pictures. So I'm trying to find out how do we came to this conclusion that it's installed incorrectly if we can't see it?
Mr. Sloan?
Yeah, the permit was issued in like February of 2013. The building inspector actually inspected the roof the day that they had it tore off. But once they finished the roof, the inspector didn't view the flashing, the overdriven or crooked nails, or the second layer of tar paper, because it was covered. And it got okayed.
So the permit got finalized?
Mm-hmm. Yeah, there were no pictures.
So how
There
did
was
we
no
final?
affidavit on that one.
What's our process for filing it?
Well, the inspector must have thought at the time that the roofing was done per the manufacturer's instructions, like you said, and okayed it. That's what happened.
So was there an affidavit signed by him that said he did it according to manufacturer specifications?
No, because the work was done during the daytime and the inspector was there.
Okay. So according to the inspector, it was done according to the plans?
Right.
So we have since decided it's not?
The board ruled against staff and in favor of Ross Larson and ruled that there was three.
Gotcha.
The board ruled that there was
The
three.
board rules, so staff believes that it was final properly. But in the Rana Grand case, the staff ruled it wasn't correct.
No, once again, in Randy Graham's, they had the affidavit, we finaled it. The council later directed staff to unfinal that permit later.
So it wasn't unfinal due to the fact that it wasn't built to manufacturer specifications. I'm just getting the information from all the information I gathered, the facts, where they're founded and unfounded. And this one completely, I'm really completely confused on what we're doing here. I have no idea.
I see Ms. Ross really wants to, I assume you had, and maybe just not if I'm correct, I assume that you had somebody else come out and look at the roof and they took off, or they then came and testified that there were overdriven and...
I just want to address the statement that there were no pictures. My husband, who in addition to having construction experience is also a bit of a shutterbug and has a lot of camera equipment, he did get up on the roof the first day when he saw the old materials, the old flashing and felt were not being removed before the new shingles were going down. That's when he saw a lot of overdriven nails. He started taking pictures that first day and continued as we continued to raise our objections, the roof continued to go on. He kept taking pictures. So we submitted dozens of photos to the building board. They did see those, and I thought that those were going to be included in your packet, so I apologize if you didn't get those. I have some photocopies. I don't know how good they are, but I have some with me.
Mr. Chair.
By all means.
And I understand that, but the fact of the matter, I got two cases pretty similar, but different. And we got one where the city, in Rana Graham's case, came back and said their verbiage is they went out and inspected it. There was two people from the city after the fact, went out and inspected it and said that it was not signed off due to manufacturer specifications. This case, we have a physical inspection of the property, and the staff believes that this roof was built to manufacturer specifications, but two complete different judgments. I guess what yield to the city attorney.
Joel, do you have anything additional?
Well, again, what option does the board have? Suspend your license. How does he get it? In the first situation, how does he get his license back if he can't go correct?
Right, and Mr.
There's no way for him to get his license back, so they chose that suspension or revocation of his license isn't an appropriate course of action. In this case, Mr. Steele, again, whether you agree with it or not, that was the rationale they used.
Right, and I understand. So basically, I got to make a decision on whether I agree with them or not, and based upon the facts, it's hard to agree with them, but I understand that somewhere along the line, somebody decided this wasn't correct. And I'm not, like we mentioned earlier, I'm not here to talk about workmanship. I'm here to talk about facts, inspections, pictures, whatever the process.
You know, as far as The inspector showed up. Let's take this case. The inspector showed up based on what the inspector could see. There was no obvious defects or problems. Now, they don't go, the only way to inspect some of this stuff normally after the fact is to tear apart the roof and actually look under it. They don't do that. They look, if there's
Mr.
no
Chair.
obvious defect, they pass the roof. Miss Ross had pictures that she was able to provide to the board in the previous hearing, which showed what they alleged, that there were problems with the roof. Mr. Steele was there. The board, after hearing from Mr. Steele and looking at Miss Ross's pictures, determined that the roof was not done correctly. So they asked Mr. Steele to go fix those issues. He did not do so, so she then appealed.
You've told me that 3 times. and I
Well,
understand
we
that.
keep going round and round.
I'm
You
not
keep
going round
asking-
and round.
Yes,
I'm trying
you
to
are.
get to the point. Mr. Chair,
By all means,
I have the floor.
you do for now.
Thank you. The point I'm trying to make, we have a process. Physical inspections. And I'm assuming the physical inspections take steps. As I read, they take the step of the tear off, and they come back and they see that the ice barrier has been put on, and that the shingles, at the end, the shingles have been replaced. And I guess I would leave that question to Mr. Salon. Is that the process? Can you give us the 2 different processes that take place? Or is there a third or a fourth or something I don't quite understand? I mean, if you're not there for physical inspections, then there's pictures that are supposed to take place. Maybe this is confusion is.
Mr. Lon.
I'm Brad from Development Services. The affidavit and pictures are only used if the work's done on nights, weekends, or
Right,
holidays.
where a physical inspection can't take place.
Right.
So if a physical inspection takes place, what is the process for that?
The inspector notes it, that it's approved or not, or if any corrections were required at the time. And then typically what we do is we follow up on a roof that's been completed and look at it. But once again, we didn't inspect the flashing, the overdriven nails, or the second layer of tar paper, because
That
those are all
required-
covered up, yeah.
Is that required by ordinance for us to look at that? Or, I mean, why do we inspect them then? Why, I guess that's my bottom line.
On the final, you mean?
Yeah, why, I mean, if we are charged to do a building permit, the person who has the permit on their house, on a roof, has a certain level of expectation that it is going to meet city code, am I correct?
Correct.
How do we ensure that, or do we not ensure that? We don't ensure that when we give that permit or final that permit? Is that not part of the process? Maybe it's me.
Well, yeah, we can't go up onto a roof, remove the shingles.
Right, I
pull the
understand
shingles
that,
up.
but
I
during
mean,
the process.
Yeah.
Because if you're not there, you require pictures.
We do, yes.
Okay, so if you're there, in this case, in the Steele case, how do we know the roof was put on correctly?
Well,
I mean,
for
by
things,
looking, but how many times do we go out there? Do we go through the process and watch the ice shield, and then what are we supposed to do, I guess?
we only do 2 inspections typically.
Okay.
We look at the tear off to make sure they tore it off, and we want to make sure that they put the ice shield on, because we're concerned that that's the first thing that will go wrong. If they don't tear the shingles off and just cover them, you can't hardly fix it. Also, if they don't place the ice shield before they start roofing, and once again, you can't hardly fix it without ripping the shingles off. So we do a tear off inspection, and then typically, like I said, there's some kind of a follow-up inspection after the roofing is completed, and the inspector looks at the roof, and it's true, the inspector's not going to be able to see some of the things that occurred during the roof, just like with any part of construction. Inside the concrete walls or inside the stud walls, you might not be able to see things that are covered.
How do we see 2 layers of tar paper?
We didn't.
I mean, is it an old layer of tar paper, or is it a new layer of tar paper? I'm not sure, I understand.
Well,
I mean, it would seem if you had 2 new layers of tar paper, that would be better.
When the inspector was there was a layer of tar paper on the roof. What he didn't know is that they put another layer of tar paper on the roof. And so
2 layers of tar paper?
So there was 2 apparently. And the
2
board
layers
ruled in favor of Ross Larson and said that that was wrong.
I'm completely baffled, but, I mean, I know this is gonna go to council Tuesday, so I'll leave it at that, and my colleagues are probably tired of me trying to get my arms around it. Thank you.
Chair recognizes Alderman Steve Laurenti.
Thank you, Mr. Chair. If I could, I'd like to ask the city attorney a question, please.
I'm sure he'd love to answer.
Mr. Lundin, I apologize for not asking this question before making the motion. But the board, the Building Board of Appeals jurisdiction, are you comfortable with this decision by the board and the rendering of the suspension? Are you comfortable with this being part of their jurisdiction?
Yeah, I think they have jurisdiction over the licensing. It's their decision to make. Now, whether or not I would have made the same decision, I'm not going to answer that. But that was within their province on licensing, whether or not to suspend or that license, which is why it went there.
Thank you very much. I yield.
Chair recognizes Alderman Richie Nordstrom, excuse me.
Certainly, you're excused. If I can ask a question of the city attorney's office, please.
Revolving door, by all means.
This can either go to Carla or to Joel. Is that, if I'm reading this correctly, this only applies to this property as far as being a requirement for the contractor to come back and redo the roof or the violations of this roof.
Carla?
Yes, the code violations were only regarding Ms. Ross's property, and so the correction of the code violations would apply just to this property. Does that answer your question?
It does. And the other part of this motion that as I'm reading the motion right now, it has to do with this only applies to this permit and future permits. Am I understanding that part correctly?
That's correct. There was a concern at the building board that Mr. Steele has other permits on other projects, and they didn't want to have citizens who had hired Mr. Steele and had part of the work done or had planned on the work being done for that to be halted. So they did apply the suspension just to future permits that Mr. Steele would secure, and it didn't apply to any permits that he'd already pulled.
So the way I'm reading again this motion is that the license is going to be essentially suspended for this project only and future projects, and once this project is corrected, then he can get his license renewed or reapplied or whatever the proper procedure is. So we're not really pulling his license altogether?
You're correct. It's not a revocation of his license. It is a suspension until these code violations are fixed.
Thank you. And so as long as he gets this property corrected, then he will be able to get his license back.
Yes, I think that's the case.
So, very good. I understand. Thank you. I'll yield the floor.
And since they filled out speaker request forms and they didn't speak, they chose to stand for questions, I'll recognize George Nelson. And
thank you. A lot of things, a lot of issues here. My letter, 6-page letter, presented a lot of issues. What I didn't hear from the city attorney was the issue of whether or not the appeal was timely by Ms. Ross. I have not seen any documentation that would verify the timeline. That goes to the jurisdiction of the Board of Appeals, whether or not Ms. Ross timely filed her appeal of the permit that approved the re-roofing of her house. That's the first issue. The other issues are whether or not the Board of Appeals correctly interpreted the building code. Now, they decided they ruled against my client on the issues of whether or not he replaced the tar paper, whether or not, I guess their wording was that he was supposed to remove the tar paper. The other issue was whether or not he put flashing on, replaced the flashing, and then lastly, the overdriven nails. I'll start from the last point, the last issue on the overdriven nails. The purpose of having nails on shingles is to keep the shingles on the house. My client put 6 nails per shingle instead of 4, which was the recommendation by the manufacturer. You have not heard from Ms. Ross as far as any leaking in the roof, through the roof, any shingles falling off, any life safety issues. She has, in my client's position, is circumventing the litigation, civil litigation, that I think the city staff wisely tried to avoid by going through this process. Now, the question is, has my client received due process? There was a November 12th meeting by the Board of Appeals based upon what? What was the appeal? My client did not receive any notice of the issues that I just received the 18th of August as far as the specific code violations. That is not due process. For him to lose his license, their licenses, or there's two families here, because Ms. Ross would like to have this matter litigated here before a city. You have a lot of resources, granted, but this is not this should not be a trial. However, if somebody's license, livelihood is going to be taken away, they are entitled to due process, which means my client's attorney being present and being allowed to ask the Board of Appeals questions. My client at the August 12th meeting was given 5 minutes to present his case. And he tried to do so in 5 minutes. That is not due process when what is at risk is his license. And again, there was no notice given to him that his license was going to be at risk. So, you 5 people here, citizens of this community, you're taxpayers, I'm a taxpayer, everybody else here, I assume, are taxpayers. We're wasting time and money based upon a dispute between 2 other parties. You have a city staff that approved this construction. The question to Mr. Sloan is whether or not the Board of Appeals correctly interpreted those city ordinances, which his staff is, I believe, interpreting much differently than what the Board of Appeals is doing. So if my client loses on this appeal, he's going to appeal, and then we're going to have more litigation because there is no due process. We respectfully ask this court, this committee, and it's sad. I feel like I'm in a trial here on behalf of my client who's trying to pay his bills and avoid this confrontation because Ms. Ross doesn't want to pay $5,000. I'll leave it at that, unless there are questions.
Thank you, sir. Chair will recognize Alderman Ron Weifenbach.
Thank you, Mr. Chair, and I appreciate it. I'm not going to support the motion on the floor just to make sure it doesn't go to the consent calendar. But in preparation for Tuesday night, I'd like to see Mr. Nelson's question answered, if that would be all right. And I had this conversation about flashing once before, about whether it's acceptable by ordinance to use flashing or whatever. And so I would like to have that addressed, and I'd like to have the second layer of tar paper. I'm not sure if I understand that completely.
There was new flashing put on. It was put on over the old flashing.
Yeah. So I guess to address those in the ordinance, how they apply to the ordinance versus, and then the second tar paper. And my understanding is our city went out there and shown that the tar paper was tore off, the roof was tore off. So I'm not sure if this is if this is 2 layers of new tar paper, or 1 layer of old tar paper, 1 layer of new tar paper, and the other one is the overdriven nails. I'm not sure, because and the reason I'm asking for this is relevant in the other situation, because we're counting nails, we're counting shiners, we're getting down to the micromanagement. And I too do agree with Mr. Nelson. This somehow has become a court, and unfortunately, that's part of the process that's taken place here, because it is. You are right. It's the livelihood of your client, and it's also somewhat what these citizens come to expect from our building permit process. And I'm feeling that there's more here to then. We got to address something else at some other point in time. So I understand that. So, but it also goes for our citizens also. So if we could get that information addressed for Tuesday night, I'd be willing to move on. Thank you.
Okay, the motion is to deny the appeal. Any further discussion? All in favor, say aye. Aye. Opposed? Motion passes 3-2 with 2 denials, myself and Mr. Weifenbach. Yes. Item number 19 is South Dakota School of Mines and Technology request the waive of banner fee. Motion approved by Weifenbach, second by Nordstrom. Any further discussion? All in favor say aye. Motion carries. Item number 20, second reading of recommendation of ordinance 5999 regarding fiscal year 2015 appropriation ordinance. Motion is to approve. This is the budget for those of you watching at home. All in favor say aye. Motion carries. Item number 21 is second reading recommendation of ordinance 6001 amending provisions concerning the general provisions of subdivisions by amending chapter 16.04.090 of the Rapid City Municipal Code. Motion approved by Nordstrom, second by Weifenbach. All in favor say aye. Oh, sorry. I shot over. Sorry about it. Never mind. Sorry. On a roll. You want me to reconsider an item? You sure? Okay. Item number 22 is for introduction and first reading of ordinance 6008 to allow child care centers as conditional use in light industrial districts by amending section 17.22.030 of the Rapid City Municipal Code. A motion approved by Weifenbach, second by Nordstrom. The chair recognizes Richie Nordstrom.
Thank you. May I ask a question of Brett Limbaugh?
Sure.
Thank you. Mr. Limbaugh, just to clarify that this will be more or less along the line of a case-by-case item, so that if it comes into an inappropriate area, then we have the authority to deny the child care in an inappropriate area.
That's correct. That's a conditional use permit process has to be reviewed by the Planning Commission, and they'll look at the surrounding land uses and other factors and determine whether or not it's an appropriate location. Thank you.
Appreciate it. Thank you. I'll yield the floor.
All in favor say aye. Aye. Motion carries. Item number 23 is introduction and first reading of ordinance 5998. In order to stop 2014 National Electrical Code by amending the Rapid City Electrical Code found in chapter 15.16, of Rapid City. Motion approved by Laurenti, second by Drew. All in favor say aye. Aye. Motion carries. Motion to adjourn. Motion by Laurenti, second by Weifenbach. All in favor? We are adjourned.